Welcome to another episode of YouTube Audio Background Studying, where we will be reading once again from a treatise on the law of torts, this being Chapter 2, Elements in Tort. To constitute a tort, three things must occur. 1. There must be some act or omission on the part of the person committing the tort, the defendant, unauthorized by law, and not being a breach of some duty undertaken by contract. 2. This wrongful act or omission must in some way inflict an injury, special, private, and peculiar to the plaintiff, as distinguished from an injury to the public at large, and this may be either by the violation of some right in rem, that is to say, some right to which the plaintiff is entitled as against the world at large, or by the infliction on him of some particular and substantial loss of money, health, or material comfort. And 3. The wrongful act, injurious to the plaintiff, must fall within some classes of cases for which the recognized legal remedy is an action for damages. Addison, Underkill. The wrongful act complained of must amount to either an infringement of a legal right or the violation of a legal duty. The general legal rights of mankind are the rights of 1. Personal security, 2. Personal liberty, 3. Private property. And private property is either A. Property in possession, B. Property in action, or C. Property that an individual has as a special right to acquire, citing Hannon versus Mockett. The main heads of duty with which the law of torts is concerned are 1. To abstain from willful injury, 2. To respect the property of others, and 3. To use due diligence to avoid causing harm to others. Pollock. The foundation of every action for tort is a wrongful act, and which may be qualified legally as an injury. An act which prima facie would appear to be innocent and rightful may become tortious if it invades the right of a third person. An act done involuntarily or under the influence of pressing danger, which the law presumes to be done involuntarily, is not legally wrongful. The crucial test of a legally wrongful act or omission is its prejudicial effect to the legal right of another. Quote, it is essential to an action in tort that the act complained of should, under the circumstances, be legally wrongful as regards the party complaining. That is, must prejudicially affect him in some legal right. Merely that it will, however, directly do him harm in his interests is not enough. End quote. Citing Rogers versus Rajendra Datta. In considering the legally wrongful act or omission, it must be borne in mind that every person is presumed to intend the natural consequences of every voluntary act or omission of his, not authorized by law, and that it is no defense to an action in tort for the wrongdoer to plead that he did not intend to cause damage, if damage has resulted owing to an act or omission on his part which is actively or passively the effect of his volition. Whether the damage caused is the probable and natural effect of the act or omission will have to be determined in each case. Alexander. Damnum and injurium. By damnum is meant damage in the substantial sense of money, loss of comfort, service, health, or the like. By injuria is meant an unauthorized interference, however trivial, with some general right conferred by law on the plaintiff. For example, the right of excluding others from his house or garden. In cases of injuria sine damno, for example, the infringement of a legal private right without any actual loss or damage, the person whose right is infringed has a cause of action. An injury imports legal damage, though there is no pecuniary loss. An actual perceptible damage is not indispensable as a foundation of an action. It is sufficient to show the violation of a right, in which case the law will presume damage. Legal damage is not necessarily pecuniary. Every invasion of the plaintiff's right or unauthorized interference with his property imports legal damage. That is, although a person injured may not suffer any pecuniary loss by the wrongful act, yet if it is shown that there was a violation of some right, the law will presume damage. In the leading case of Ashby v. White, Lord Holt, Chief Justice, said, quote, "A damage is not merely pecuniary, but an injury imports a damage, when a man is thereby hindered of his right. As in an action for slanderous words, though a man does not lose a penny by reason of speaking them, yet he shall have an action. So, if a man gives another a cuff on the ear, though it cost him nothing, no, not so much as a little dilatation, yet he shall have his action, for it is a personal injury. So a man shall have an action against another for riding over his ground, though it do him no damage, for it is an invasion of his property, and the other has no right to come there." End quote. Where the defendant, a returning officer, wrongfully refused to register a duly tendered vote to the plaintiff, a legally qualified voter, and the candidate for whom the vote was tendered was elected, and no loss was suffered by the rejection of the vote, nevertheless it was held that an action lay, citing Ashby v. White. Where the roof of a house projects over another man's land, the drip of the rain water is taken to be damaging previous to evidence thereof, citing Fay v. Prentice. An action will lie against a banker having sufficient funds in his hands belonging to a customer for refusing to honor his check, although the customer did not thereby sustain any actual loss or damage, citing Mazzetti v. Williams. Leading case, Ashby v. White. The decision in this particular case of Ashby White occasioned one of the more furious controversies between the House of Lords and Commons, of which there is any example in English history. It arose from an idea entertained by the Commons that the attempt to bring a case involving the right of the elective franchises before a court of law was a high breach of the privileges of their House, and they proceeded so far as to order that Mr. Meade, Ashby's attorney, should be taken into custody and to commit the plaintiffs in several similar actions to Newgate. In cases of damnum sine injuria, i.e., for example, actual and substantial loss without infringement of any legal right, no action lies. Mere loss in money or money's worth does not of itself constitute legal damage. Damnum may be absque injuria, as, if I have a mill, and my neighbor built another mill, whereby the profit of my mill is diminished, I shall have no action against them, though it is damage to me. But if a miller disturbs the water from flowing to my mill, or doth any nuisance of the like sort, I shall have such action as the law gives. Per Justice Hankford in Gloucester Grammar School. Acts done by way of self-defense against the common enemy, such as the erection of banks to prevent the inroads of the sea, are instances of damnum absque injuria, and damage resulting therefrom is not actionable. Where the defendant, the schoolmaster, set up a rival school next door to plaintiffs, and boys from plaintiff's school flocked to the defendant's, it was held that no action could be maintained. Gloucester Grammar School case. Where the defendant had sunk a deep pit on his own land for mining purposes and kept it dry by pumping in the usual way, with the result of drying up a well which belonged to the plaintiff and was used by him to supply his cotton mill, it was held that no action lay. Acton v. Blundell. Where the defendants had sunk a deep well on their own land to obtain a water supply for the town, and the making of this well and the pumping of great quantities of water from it intercepted water that had been formerly found its way into the river by underground channels, and supply of water to the plaintiff's mill was diminished, it was held that the right claimed by the plaintiffs was too large and indefinite to have any foundation in law, citing Chasemore v. Richards. In a very recent case, it was alleged against the defendant that he intended to divert underground water from the springs that supplied the plaintiff's corporation's works, not for the benefit of his own land, but in order to drive the corporation to buy him off. It was said that this might be unneighborly conduct, but could not be called malicious, the main object being not harm to the plaintiff, but gain to the defendant. The dictum in Chasemore v. Richards was approved. Corporations of Bradford v. Pickles. A mine owner getting his coal in the manner most convenient to himself is not liable, although in consequence he lets water flow into his neighbor's mine. But it was also added that the damage must not arise from his neglect or malicious conduct, citing Smith v. Kenrick. Where a person owns a shop which greatly depends on its own custom upon its attractive appearance, and a company erects a gas meters hiding it from public, he cannot sue them, because although his trade may be ruined by the obstruction, yet the gas company are only doing an act authorized by law, namely building upon their land, citing Butt versus Imperial Gas Company. Where a landowner by working his mines causes subsistence of his service, in consequence of which the rainfall was collected and passed by gravitation and percolation into an adjacent lower coal mine, it was held that the owner of the latter could sustain no action, because the right to work a mine is a right of property, which when duly exercised begets no responsibility, citing Wilson v. Waddell. The seduction of a daughter not in her father's service, actual or constructive, citing Blamoni v. Haley, Davies v. Williams, the seduction of a daughter in her father's service, unless an actual loss of service accrue, citing Eager versus Grinwood, are damna absque injuria. Where the servants of a Hindu temple had a right to get the food offered to the idol, but the person who was under an obligation to the idol to offer food did not do so, and the servants brought a suit against them for damages, it was held that the defendant was under no legal obligation to supply food to the temple servants. And though the result of this omission to supply food to the idol may involve a loss to the plaintiff, it is damnum absque injuria, and cannot entitle the plaintiff to maintain the present suit, citing Dadfak versus Guro. Leading cases: Chasemore v. Richards. Damnum e injuria. The combination of these two ingredients will fail, for particular reasons, to constitute a ground of action. To this class may be referred every case in which an injury done productive of damage to another is in legal contemplation too remote to entitle the injured party to redress, or in which the injuria did not, with sufficient distinctness, produce the damnum broom. Damage and damages are neither equivalent terms, nor in this latter the plural of the former. Damages are compensation in the form of a sum of money, which the court awards for every injury. But the damage which every injury imports is that which is supposed to be compensated by this award of damages. And such damage may consist wholly of a money loss, or partly so, or not at all of such. It is impossible to conceive of an injury or legal wrong that shall not import or result in damage in this sense, and then some award of compensation, however nominal, is obviously incumbent unless wrongs are to go wholly unredressed. Hence the term damage is sometimes used where injury would be more correct. But the two terms and the notions they signify, though correlative, are perfectly distinct. Colette. Damage is necessary to be proven by the plaintiff before bringing an action against the wrongdoer in the following cases. 1. Right to support of land as between adjacent landowners. 2. Menace. 3. Seduction. 4. Slander. 5. Deceit. 6. Conspiracy or confederation. 7. Waste. 8. Distress. Damage feasant. 9. Where nuisance consists of damage to property. And 10. In actions to procure third persons to break his contract with plaintiff. Malice. This is not a necessary ingredient to the maintenance of an action for tort, where damage is occasioned by a wrongful act, that is, an act which the law esteems an injury. Malice, in the common acceptation, means ill will against a person, but in its legal sense, it means a wrongful act done intentionally without just cause or excuse, citing Bromage versus Proser. Malice in its legal sense is something less than malevolence or vindictive feeling. Acts done wrongfully and without reasonable and probable cause, and acts done vexatiously and for the purpose of annoyance, have been held by the law to be malicious, citing Gautry versus Robert Chirol. Malice is said to have been present whenever the injurer contemplated harm to the person injured, though he may also have entertained a desire to benefit himself. and though the harm contemplated may be merely incidental to the fruition of that desire. Malice is variously spoken of as express malice, actual malice, malice in fact, and malice in law or implied malice. The first three terms are identical in meaning. Thus, malice is of two kinds, express malice and malice in law. Express malice is what is known as malice, and malice in law is implied malice as well as express malice. That is, when from the circumstances of the case, the law will infer malice. Express malice is an act done with ill will towards an individual. Malice in law does mean an act done wrongfully and without reasonable and probable cause, and not, as in common parlance, an act dictated by anger, feeling, or vindictive motives, per Chief Justice Best in Stockley v. Hornage. It follows, therefore, that where an act unlawful in itself is done intentionally without just cause or excuse, the law will infer malice. Also, malice in law depends upon knowledge, malice in fact upon motive. Clerk. The three ingredients then of malice in law are intention to do the act, a wrongful act, and the absence of just cause or excuse for doing it. And these are the three ingredients of all torts. All torts are therefore malicious in law. Pijot. For instance, A says to B, a school mistress, in the presence of D, E, F. B made a willful false statement to the visitors about the number of children attending daily. Here the imputation is as to the conduct of B in the management of her office. It is therefore defamatory. If it is also not true, malice, called also malice in law, is implied by the law, and it is not necessary for the jury to find it. In an action for malicious prosecution, it is shown that A, on mere rumor, believing B to be guilty of murdering of C, falsely charged him with it. But the wrongful called malicious prosecution is not committed unless malice is shown to have been actually entertained in the matter by the person against whom the action is brought. Malice on the part of the defendant, of which evidence is thus laid before the jury, is called malice in fact. Express malice is not necessarily malice in law. For instance, the prosecution is set on foot with the most express malice, but with reasonable and probable cause, will give no ground for an action to recover damages for malicious prosecutions. Alexander. The Madras High Court has held that the inference of malice in civil cases is a matter of fact, and the mere absence of reasonable and probable cause for an act does not justify the concluding as a matter of law that the act is malicious. Citing Rajuranda Rao v. Nath Muni. This shows that the absence of reasonable and probable cause is not to be taken as identical with malice. When the act complained of is in itself unlawful, the law will infer malice. When lawful, malice will then be proved. Intention, mens rea. When the doer of an act adverts to a consequence of his act and desires it to follow, he is said to intend that consequence. An act must always be intended, although the consequences of an act may not be so. Mark B. The obligation to make reparations for damage caused by the wrongful act against right or law arises from the fault and not from the intention. A thing which is not a legal injury or wrong is not made actionable by being done with a bad intent. But in many cases, to constitute an act a legal wrong or injury, the existence of a malicious intention is essential. Where an act in itself indifferent is done with a particular intent becomes wrongful, then the intent must be proved and found. But where the act is in itself unlawful, the proof of justification or excuse lies on the defendant, and in failure thereof the law implies a wrongful intent. Citing R. v. Woodfall. There is a kind of wrongs in which either a positive wrongful intention or such ignorance or indifference as amounts to guilty recklessness is a necessary element, so that liability is founded not in an absolute right of the plaintiff, but in the unrighteousness of the defendant, Pollock. These are 1. Deceit, 2. Slander of title, 3. Malicious prosecution, 4. Malicious arrest, 5. Maintenance, 6. Seduction, 7. Defamation, 8. Conspiracy. And wrongful acts done with intention are often said to be done maliciously. Bodily injury through the consequence of a lawful act or a mere mischance may be a tort, and the existence of an evil intention in the mind of the wrongdoer is not essential. So much so that even a lunatic, much more a drunken person, will be civilly answerable for his torts, although wholly incapable of design. Broom, Sedgwick. The question of the intention of parties is never a question of law, but of fact. In criminal trials, much attention would necessarily be paid to the animus of the defendant, as without the mens rea he could not be convicted. In injuries in respect of real property, which had all along been redressable by civil action, all that was looked to see whether the defendant was entitled to redress was the fact of the invasion of the right by trespass or otherwise. But in personal injuries, as libel and slander, false representation, etc., when they became actionable, the civil courts, perhaps adopting the practice of the criminal courts, continued to regard the mens rea as an indispensable ingredient in the injury, which was dealt with as a quasi-crime. Innes. The maxim, quote, "a man is presumed to intend the natural consequence of his acts," end quote, is a proposition which, says Pollock, with due explanations and within due limits is acceptable, but which in itself is ambiguous. Sometimes we have independent proof of the intention of a man doing an act, as if he announced it beforehand by threats or boasting of what he would do. But oftentimes the act itself is the chief or sole proof of the intention with which it is done. We say that the intention is presumed, meaning it does not matter whether intention can be proved or not. Nay, more, it would in the majority of cases make no difference if the wrongdoer could disprove it. Chief Justice Bryan said, quote, "The thought of a man is not triable," end quote. But though we do not care whether the man intended the particular consequence or not, we have in mind such consequences as he might have intended, or without exactly intending them, contemplated as possible, so that it would not be absurd to infer as a fact that he either did mean them to ensue, or recklessly put aside the risk of some such consequences ensuing. This is a limit introduced by such terms as natural or natural and probable consequences. What is the natural and probable in this sense is commonly, but not always, obvious. There are consequences which no man could, with common sense and observation, help foreseeing. There are others which no human prudence would have foreseen. Between these extremes is a middle region of various probabilities divided by an ideal boundary which will be differently fixed by different opinions. Where the defendant, a balloonist, came down in the plaintiff's garden, whereby a crowd of people broke into the garden and trode down the vegetables and flowers, the defendant's descent was considered to be a trespass, and he was held liable for the damages done by the balloon and also by the crowd, citing Guile v. Swan. The defendant, with a certain amount of provocation, seized a pickaxe and chased a little black boy through the streets of a town. The boy, in terror for his life, bolted into the plaintiff's store, and in his hurry knocked out the faucet from a cask of wine, whereby the wine ran out and was lost. It was held that the defendant must pay for the liquor because he was a wrongdoer in pursuing the boy, citing Vandenberg v. Trucks. The plaintiff was looking at the defendant, who was uncocking a gun. The gun went off and wounded the plaintiff. It was held that he could recover, citing Underwood v. Hewson. The defendant, in mowing his own lawn by accident and as alleged unintentionally, mowed a little of the plaintiff's land. He was held liable. Quote, the fact being voluntary, his intention and knowledge were not traversable. They cannot be known, end quote, citing Baisley v. Clarkson. In a case, damage to a pier had been occasioned by a vessel driven against it through the violence of the wind and waves. At a time when the master and crew had been compelled to escape from the vessel and had consequently no control whatever over it, the House of Lords held that the owners were not liable. Lord O'Hagan said in his judgment, quote, the ship should be dealt with as if it had been abandoned at the antipodes and had been plowing the ocean without a crew for years before it was driven against the pier, end quote, citing Riverware Commerce v. Adamson. Motive. Intention and motive are not identical. Intention is the mental relation of the result aimed at by the act done, but motive begets the volition that intends such act. In criminal cases, intention and not mere motive is material. The two may often concur, and clear proof of the motive may often demonstrate the intention. But a commendable motive will not excuse an illegal intention. In civil cases, intention may be immaterial, since the fact of a legal injury or breach of right of itself induces civil liability. But in all cases, if a wrongful act is done intentionally, without just cause or excuse, this is a sufficient intention to injure and ground of liability, whether the motive that prompted such intent be good or bad. Collect.